Hello, everyone. Hope you're all doing very well. Welcome to McEntee Law Group's First Fridays, our special Second Friday edition. My name is Ryan Helgeson. I'm a senior immigration attorney here at McEntee, and I'll be covering a lot of recent updates in immigration law for you, as well as answering questions you might have during the program. First, I'd like to remind you that though I am an attorney, I am not your attorney, so I'm not providing advice specific to your cases. If you do have questions about a specific case, I recommend you reach out to us so we can have a one-on-one consultation. Also, a reminder that we are live, so there is no confidentiality. So keep that in mind if you're entering comments in the chat. There are lots of topics to discuss as it's been a busy few weeks in immigration as we prepare for the transition from the Biden to the Trump administration. The Biden administration has been finalizing and solidifying some rules, building upon previous executive orders and goals they've had. Also, as I'm sure you're all aware, on the campaign and recently in the news, President Trump and his team have been hinting at their plans for immigration. Most recently, President Trump said he's planning on issuing 100 executive orders on day one, several of which will likely deal with immigration. We'll discuss those likely plans and how to prepare for those scenarios in a little bit. I'll also be talking about new federal regulations that impact H-1B visas, new USCIS policy manual updates regarding O-1 visas, looking at employment authorization automatic extensions, and then finally we'll finish up with any questions you guys may have. So addressing the 400-pound orange primate in the room, we don't have any specifics on Trump's plans as of yet, but based on his hateful rhetoric on the campaign trail and what we experienced in his previous term, we can make some educated guesses about what's upcoming. He is going to ensure that money and resources are wasted on building a border wall, probably through declaring unlawful immigration as a national emergency, so he can have access to the money that brings. He is likely to try to re-implement Title 42 restrictions. As a reminder, Title 42 was put in place during the COVID pandemic. It's a public health related provision that is used to close the border essentially to many people. Title 42 was suspended in January 2023 by the Biden administration, but it is pretty likely that Trump will try to re-implement that. He's also going to start ramping up infrastructure for his pledged mass deportations and enact sanctions against sanctuary cities to try to get them to comply with his hate-filled dreams. In connection with the threatened mass deportations, I did want to discuss a bit about knowing your rights. A lot of the deportation, if it occurs, would occur through what's known as expedited removal. So ICE can remove individuals without a hearing or due process if they can show that you've entered without documentation and have been here less than 2 years. Those in that status, or really anyone without secure immigration status, may be subject to these enforcement actions. Therefore, it's best to kind of have to pre-plan for this. First, you should seek legal consultation to determine if there's a path forward for you and your family to gain lawful status, if that's necessary, to secure or to get a more secure status. You should create a safety plan. Have emergency contacts for all your family members. Become familiar with ICE's online detainee finder in the event that someone in your family is detained during a raid or a similar action. And in worst case scenarios, probably familiarize yourself with guardianship and power of attorney considerations in the event that families are separated. Additionally, you should collect all of your documents, both identity and financial information, in a safe place. This should include documents that show you've been here, been present in the U.S., particularly during the last 2 years, like tax returns, utility bills, leases, school records, things like that. And your emergency contacts should also have access to copies of these documents. Finally, while all of this is going on, it's important that you be aware of potential immigration fraud. So lawyers must be licensed. So before, getting involved in possible immigration proceedings, you should, make sure to see your lawyer's license and get copies of all documents that you sign. Never sign an incomplete document or a blank document, and also be alert for digital scams. Advertisements that are promising, quick, immediate immigration relief. Those things generally do not exist. So maintain, a healthy skepticism around that. Also, you've probably seen in the news that a lot of universities have issued travel recommendations to their students and professors who are traveling abroad during the holidays. The last time Trump took office, a lot of some travel bans were issued on day one. And in the event that this happens again, we recommend that all F1 individuals on F1s or professors and researchers on O1s, J1s return to the United States before the inauguration on January 21st, regardless of when your school term starts. This will ensure that you're back in the U.S. safely in status, and don't risk getting stuck abroad, in where it can be very difficult to address any issues. Additionally, talking in general about visa applications under the Trump administration, there's no specific plans for, changing or eliminating categories, anything like that. But based upon last time, it's, there's going to be stricter scrutiny on all applications. Regulations will probably be interpreted very narrowly. Processing times will slow down. There'll be more requests for evidence. So things will just be more difficult. We've seen this before here at McEntee. We've stayed ready rather than having to get ready for this instance. We've prepared petitions, based upon, what occurred during the last Trump administration. So we're extremely thorough and cover all the scenarios. Make the best and strongest case possible up front. So we're, so even though things will get more difficult, we've seen it before, and we kind of know what that's going to look like. Turning to the new H-1B regulations. First, as a quick reminder, H-1Bs are a non-immigrant visa for those in specialty occupations, which means it's a position that requires at least a bachelor's degree in a specific field for entry into the occupation, and then the individual has to have that degree. USCIS issued a final rule, which will go into effect January 17th. The rule itself, the Federal Register notification of it, is 460 pages long. Yes, I have read it. It's horrifically boring, but because of that, I'm just going to touch on some highlights and some basic themes that kind of that the new regulations cover. The most important change they're making is clarifying the definition of specialty occupation. It's not a change to the definition; it's more of a clarification. Specifically, the degree that's required in a specific specialty to qualify as a specialty occupation. So the language they're using is directly related to the job. So this is a focus on emphasizing that a range of degrees may be possible or may be required for a specific position. The emphasis they're making is looking at the not necessarily the title of the degree, but the coursework that went into it. It's an attempt to focus more on allowing employers to get the talent they need with the skills they need, rather than a specific type of degree or a specific title degree. So it does allow more flexibility. I think in general this is a good change. It allows more flexibility with the requirements for the degree and then the education that the beneficiary may have. So I think it benefits both the employers in being able to find the right people and the beneficiaries in matching up their qualifications with the job. Additionally, the regulations provided for the elimination of specific day-to-day itineraries for those in consultants, but the individuals should be, or companies should be prepared to include the third party's needs for a specialty occupation. They provided clarifications on remote work from within the U.S. In relation to defining what a U.S. employer is. They provided more information about what qualifies as a CAP-exempt organization. They've loosened the restrictions on that, so more entities will qualify for CAP exemption, which is very important given the strict limits on the number of H-1B visas granted each year. The change there is that instead of research being the primary focus of the nonprofit or the government institution, it can be a fundamental activity of the entity. So it's it kind of widens the scope of who can qualify for CAP exemption. They're also increasing the CAP gap extension of employment authorization. So previously, if you were selected in the lottery, and you're applying for an H-1B visa, and between April and June is the normal timeline, and your OPT or STEM OPT expired in, say, July or August, while the H-1B was pending, or and then when it was approved, your employment authorization would be automatically extended through September 30th, for the H-1B position to begin on October 1st. Because of processing delays and RFEs adding additional time, they've changed that rule. So now the employment authorization is extended through March 31st of the following year. So basically you have an additional 6 months of automatic extension while your H-1B petition is pending for a CAP-based petition. So that's excellent news. It eliminate any gaps of employment. Finally, for beneficiaries that also own or have a controlling interest in the entity that's petitioning for them, they've defined a controlling interest as majority ownership or majority voting rights, and they've added limitations to that. So it's initially only going to be valid for 18 months rather than 36, and it's eligible only for one 18-month extension rather than an additional 3 years. So beneficiary owners are capped at 3 years rather than 6 under the new regulations. So that's it's good that they've provided a little clarity on that, but obviously not so great that they've limited the H-1B timeline for those individuals. Additionally, this past Wednesday, 2 days ago, USCIS updated their policy manual for O-1 visas. As a reminder, O-1 visas are for those with extraordinary ability in the sciences or business or in the arts, motion picture industry. The executive order, an executive order was issued in October of 2023 that focused on promoting the use of O1 visas for those in emerging technology fields. These policy manual updates build upon that executive order. As I said, they were issued on Wednesday. They went into effect immediately. Pending O1 petitions will be adjudicated under these policy manual standards, and any petitions applied going forward will be also adjudicated under these standards. As a note, this is a policy update, not a regulation. So it's more of an interpretation of the regulation that can be changed the same way that the Biden administration just changed it. The Trump administration can do the same thing. But this does, put a barrier up for future changes. One of the important changes that is expressly states that the beneficiary can own the company that is acting as the petitioner. This has always been the case, but now the policy manual directly states that. So when a petition is filed, we have direct language, express language we can point to for that situation. It also provides a lot of clarity on evidence that can be used to meet the criteria, and they provide a wide range of examples for each of the categories that exist for the O1. For example, under the awards category, they note that they can be early career awards, or that they can be team awards rather than individual. So there's more ability to access qualifications for that criterion. Regarding original contributions to the field, one of the other criteria, they focus a lot on emerging technologies and the types of evidence that those individuals can use to meet that qualification. And then they also provide a lot of additional information on what qualifies as an event, so that you can, when you're applying for an extension, you have more clarity on whether you're going to be eligible for a 1 or 3 year extension of the O1. So in general, the policy manual strengthens what has been the practice under the Biden administration, and provides, particularly for those in STEM and emerging technology fields, provides a stronger basis to qualify for an O1 visa. Finally, the USCIS issued a 540-day automatic extension of employment authorization for certain categories. This was made permanent. It used to be that a 180-day extension was available, and now they temporarily made it 540 days. They've now made that permanent 540 days for certain categories. So this will minimize any gaps in employment authorization due to processing delays of employment authorization applications. Importantly, it does require that your employment authorization extension have been timely filed, and it must be in the same category. So if you're switching from an L2 to an H4, you're not going to be eligible for that extension. The categories that are covered by this include refugees, asylees, and asylum applicants, those in TPS status, and several others. It does include spouses of EL and H-1B visa holders, but the extension may only go through the validity on the Form I-94. So you can't actually get that full 540 days, unless your I-94 is 540 days in the future. So in practice, the automatic extension doesn't necessarily apply to EL and H-1B or H-4 spouses. We did have some questions come in before we started today, so I wanted to address a couple of those. There was one on kind of what O1 adjudication would look like under the Trump administration. I think we've covered that. It's just going to be stricter, but there are the new policy updates which we can use to, to our benefit to make a stronger case for those individuals. There was a specific question on press coverage as one of the categories in the O1 visa and how USCIS kind of looks at that. They are quite strict on what type of press qualifies as legitimate. So it has to be a legitimate independent source with a definable circulation or audience. So you're looking at trade publications in your specific industry or major media. This is not somebody's independent blog. It's not a company newsletter. It's not a small one-off podcast. Those type of things. These are we want to be able to show that the publication the press appeared in whatever media was has a wide audience and is applicable, is going to reach people in your field. So trade publications obviously are aimed towards other experts in the field. And major media has a wide circulation. So if it's regional news network, newspaper coverage, podcasts or white papers that have a wide audience, those type of things would qualify as good press coverage that can be used for the O1. There were several questions provided about specific scenarios. I won't be able to address those here. Those individuals with those questions should reach out to us, and we can schedule a consult to talk about your particular options, because there's a lot of things to consider that we can't really cover here in this venue. There was another question about compensation while working for a startup, particularly while on a STEM OPT. The individual is correct that salary and stock options can be considered as part of the compensation. Another thing that's important to notice and that we often use is if the startup has done any funding, which has resulted in a valuation of the company, then the beneficiary's percent ownership can be considered kind of the equivalent of a salary. We often use this when we're looking to meet the high salary requirement for an O1 or an EB1A type of visa. So I think that covers everything I wanted to talk about and the recent happenings. There's talked about the H-1Bs and the O1 updates. Obviously, January 21st, a lot of things are going to happen and things are going to change, in the coming weeks and months. But we'll be back every first Friday to discuss those, and we have all of our social media will provide you with lots of updates as they come out. We're gearing up for this change just like everybody else is, and we'll keep you abreast of any of the developments that happen as the Trump administration takes office and tries to implement their plans. So if there are no other questions, I believe that will cover everything today. Thank you all very much for attending. I appreciate you guys being here. We're happy to provide this service to you and this information. I hope you found it helpful. Thank you very much. Have a wonderful day.